Good afternoon and welcome everybody to our HR quarterly update. So glad you could join us. My name is Pieter de Ruiter and I'm employment lawyer at Pallas Attorneys at Law. Today I'm joined by my colleague Nikki de Groot. Welcome, Nikki. We got a number of interesting topics to discuss with you today. These are the following. Nikki will start and tell you more about hybrid working, non-compete clauses in the Netherlands. After that, I will further discuss the position of the statutory director in the Netherlands, and I will also tell more about the implementation of the EU directive on transparent and predictable employment conditions. And lastly, I will also discuss the Paid Parental Leave Act that will enter into force as per 2 August of this year. So we got a lot of ground to cover. But before I give the word to Nikki, I want to let you know that you can ask questions in the chat. They will pop up at my tablet here, and we will try to discuss all of those questions at the end of our presentation. So with that, I would like to give the word to Nikki to start off with, and let's give you also the remote. Here you go.
Thank you very much, Peter, and thank you for joining during this warm summer day. I will start off with a really hot topic, hybrid working. We got a lot of questions about hybrid working. Of course, this has everything to do with COVID. Before COVID, working remotely or working partly remotely, partly at home, or partly at the office was not the day-to-day practice. That's something else we see now. So looking at the trends, before COVID, most people worked 4 hours per week, approximately at home. During COVID, that was, depending on where you work, it was full-time. And after COVID, we see a tendency that 20 or 30% work at home and the rest in the office. So we see a development from the office to home office to hybrid, and we see hybrid as partly at home and partly in the office. Of course, with hybrid working, there are a lot of pros and cons, and because you want to have best of both worlds, I just want to touch upon the pros of the home office. We know from our clients and their employees that they could focus more, they have improved productivity, there's less time to commute, obviously. They can combine their work with care responsibilities, so with their family or with other care duties. They have more flexibility in terms of hours, but also in days. For the employer, there are certain cost savings. Of course, your office building shouldn't be that big. People will have a desk at home and need some of the facilities, but not double. And then the pros of the office. People want to have social interaction. If you have to collaborate a lot have to work in teams, there you can find group dynamics in the office, which is quite hard to find that via Teams or Zoom meetings all the time. The pro also from the office is that you can ensure employee engagement and inclusivity. People have more meaningful jobs if they think they are needed and they are seen by their colleagues in a face-to-face setting. What is also, and that's something we also noticed more from the employment law side, is that it's more easily to train people in the office than at home, due to the face-to-face time. And if you need any performance improvement, it's also more easily to guide them. If there's a case that an employee is sick, the rehabilitation of sick employees is also quite hard at home and more easily in the office. So combining those best those worlds and having best of both worlds, it's very challenging for you as an HR professional. It's those challenges can be partly sorted, but it also has to do with picking the best hybrid work model for you, for your company. And those challenges is, of course, the loyalty and social engagement, to ensure the teamwork, the choice of location. On one hand, you want to be flexible, but you also want to have availability of people, and don't be too flexible. Another challenge is, how will I manage the allowances people are entitled to? So thinking of working from home allowance or travel expenses. Also the facilities, both at the office and at home, should be covered. At home, there's also a challenge of confidentiality and information security. It's really hard to monitor, of course, but of course there are some solutions to it in terms of systems. What I touched upon earlier had the rehabilitation of people and making sure that the work environment is healthy and safe. That's also one of the challenges, and the privacy of people. If you look at monitoring people and all the time or once in a while, or of course you have systems for that, but just to take into account those challenges for your hybrid work structure. Part of it can be solved in a very clear hybrid work policy. I just mentioned some topics which could be in there, and we think it's wisely chosen to have those topics in the hybrid work policy. Then you could limit the locations of people. Could that be anywhere, or is it just the home office, the home address and the office, or could it be abroad or not? And what is also the allocation of those locations? Not every position can be hybrid, we think. Some positions in a digital environment, it's more easily, but sometimes you want to have, for example, your office manager at the office, because there are some things to be dealt with in the office, so you cannot do that hybrid. So there are some things that you make some position eligible for a hybrid and some don't. Also to prevent the discussion. Then the allocation. How will you manage that? Is that certain days per week, certain days per month, or do you count on certain days during a quarter? Making yourself available and also keep an eye on the working hours is also a good topic to have included in the hybrid work policy. What I mentioned earlier, also the allowances. Are employees entitled to an expense allowance or to travel expenses, and how will you keep track of that? Then the health and safety of course of the workplace, and then we mean having such thing in the hybrid work policy. It should be more a prescription. What is healthy? What's a healthy and safe workplace, and giving some more instructions, more from the prevention side. Of course, if somebody falls sick, you also need to follow a procedure, and that should also be covered in the hybrid work policy. And then the performance. So I think in a hybrid work policy, this will be also monitored in a different way. So think about KPIs or targets, and how will you keep track on that. Yeah, maybe a little bit the pitfalls of the hybrid work policy. Of course, with the hybrid work policy, you are changing the regulations. And if you have a works council, you should involve the works council. And thinking about if you're changing the working conditions, or if you have a rule on the monitoring, or on the process of the protection of privacy, or how you will schedule meetings. Those are regulations that should be consulted with the Works Council. And because you want to implement this hybrid work structure, you may or may not implementing technology facilities. And for that kind of regulation, you need also the advice of the Works Council. Another pitfall you may encounter is that at some point you want people to profit from this hybrid work structure, but in some situations you want them back in the office. So it will be good to have a situation described that if you have a situation of performance, of illness, that you can ask the employee to be more often in the office than at home, because the procedures can be followed more easily. So also in general, an important thing, if we compare this to a working from home policy, which was temporarily during COVID, this has some impact for the long term, and it's also quite hard to change it back to the former situation. So it should be very think through, and because there is no limitation in duration, most of the time all the situations should be covered in this hybrid work policy, and you cannot fall back on, oh, but this is what we're going to change in a few weeks back. I shortly discussed the locations, and we see from our clients also many questions that employees actually want to work in hybrid, but then remotely from abroad. But that is a different ballgame. There are surely different pitfalls working abroad. What I just mentioned the main pitfalls, and if you allow your employees working abroad, then you will certainly have applicable employment law from abroad in place. It has some consequences for the social security and for wage tax, so in some cases also corporate tax. Some of the employees need a work permit to work in another country, the same as other people need a work permit here in the Netherlands. And it's hard to track on health and safety. Are there solutions? Yeah, we might say, yeah, of course there are solutions. It will take some time to get the best structure, but we think you can offer an international remote worker agreement to cover all those pitfalls and challenges. So at least you have a written confirmation of all the arrangements made. So we have also more clarity for both the company and the employee. As hybrid working is a hot topic, we also have a report of the socio-economic board, and they advised on hybrid working, and say, yeah, of course, it should be tailor-made. And what also is important, consult the Works Council for the policies. Also take a special attention to physical and mental health, because we saw some research that hybrid working is has an impact on the mental health of many employees. So that's an important development to follow, but also to think about how can we prevent cases like that. And of course, they touch upon information security. Another development in the context of hybrid working is the proposed legislation, Work Where You Want. It's still a legislative proposal, but we just recently, the 9th of June, had a development or it was actually adjusted, that formally before this proposed legislation will take into effect, the situation was that every employee could file a request in writing for change of hours and work location, but that was then subject that the employee should be employed half a year, and the company should have at least 10 employees. This will change by the proposed legislation. Every employee can file a request, and the request should at least substantiate the motivation for it, and the interest of the employee should outweigh the interest of the employer. And that's the new threshold from the 9th of June, that it's there are no serious business interests needed, just a balancing of interest between the interest of the employee and the employer. So this was my topic on hybrid working. Maybe is there any question on it?
Yeah, we got one question coming in, and someone is asking what allowances are employees entitled to when working from home?
Yeah, there is no legal obligations to provide allowances, but of course you need to ensure a healthy and safe work environment. So maybe it's just more an advice to provide facilities like a good chair and a good desk to provide those things. Yeah. But we saw also hybrid work policies in which people are entitled to expenses like for the internet or phone. Yeah. But that's not a legal obligation, but it could be advised to make it more attractive, and also in terms of health and safety, it's advisable to support in terms of facilities.
Yeah. I think also there's not a legal obligation, but there's a tax-free allowance that's coming from the Dutch tax authorities that say, okay, you can provide the employee with a tax-free allowance, which is fixed to cover for cost of coffee, things like that at the home office per day. Mm-hmm. So that could be an incentive for the employer to say, okay, I'm willing to provide someone with an allowance to work from home.
Sounds good in terms of employability, of course, to make it attractive. And but then again, there's no legal obligations.
No legal obligation to provide.
No. Yeah. All right. My next topic is about non-compete clauses. We got a lot of questions about non-compete clauses lately. Of course, because of the war of talent, people are in need of new employees and try to hire and recruit people. And then sometimes the former employer don't want their employees that they will leave. and they enforce the non-compete clause. That's a kind of a new development, I guess, because of this war of talent, and this will lead to more discussions, and maybe in the near future also to more cases. So actually we see a wide use of non-compete clauses. I think the report shows that 30% of the employees have a non-compete clause. That means 3 million employees, and maybe it's good to see the developments on it. I will discuss it shortly on the report, the current regulation, the case law, and the policy proposal. Actually, the Ministry of Social Affairs and Employment requested a research company to make a report on non-compete, and they also involved legal professionals and other researchers. It's maybe they made an overview. What are the trends? How is this non-compete functioning in the Netherlands? And also made some recommendations for the future. And if we look at the case law, the report made a summary of that, and 53% of the non-competes in case law were suspended by the judge, and 37% it was upheld. And if we look at the overview of case law, it was in more than half of the situations the initiative of the employee. So yeah, we see that the use of the non-compete has been increased, and that has also been confirmed by the report. Actually, in the Netherlands, there is a low threshold to include a non-compete. There's no financial compensation needed for it. But then again, of course, it has a lot of consequences for the employee, because he will be limited in his opportunities in the work market. So currently the employee have to demonstrate that the employer has no legitimate interest to rely on the non-compete, and we see a development. There's a broad support to change the rules on the non-compete clauses. What is the situation now? I think there's a strict test to agree to a non-compete. One, it should be recorded in writing, agreed in writing, and there should be a clear clause in the employment agreement. Please note, if you convert, if there's a conversion of the employment agreement, that's still valid. So, or it should be agreed again, or it should be confirmed that in the extension letter that there is a non-compete clause, and of course this will be valid in the next role. We, by law, there are still for the fixed employment agreement, there's a motivation and substantiation needed for the business interest of the employer. So basically what we also see, don't use the standard clause of the permanent contract, make it very specific, but also list the business interest of the employer, why this clause, this non-compete clause is needed. And the test is always the balancing of interests. So the employer should have a reasonable interest for this clause at the beginning, but also at the end. And as we see recently, some case law and maybe not to discuss this case by case, but more general, what we can learn from it is one, the non-compete clause is cannot be upheld in court if it's only for retention of employees. The judge will look at it from another angle. The non-compete can also only be enforced if you can, if you need it to protect your business, in terms of that the employee gives the new employer an advantage, and that only exists because he takes certain skills or work process with him or products, and with this knowledge gives the new employer some advantages over the former employer, and therefore it's competing. And for that situation, you can protect your business a bit with the non-compete clause and enforce it also when it comes to when it will be invoked in the court proceeding. And what we see just in the field is that employers think that they just can restrict their employees just by a non-compete clause, and they don't think through the consequences for the employee, but more importantly, to think their own about their own consequences, and see that they need a good substantiation for this non-compete, but also make it tailor-made to the role. But you cannot come up with a standard clause for every employee in the company. Of course, there are certain roles in the company who have certain knowledge, and that's not the case for the office manager, or maybe the drivers, or with more. Maybe more the people who have the knowledge about the product, about the service, about the sales. Because of this report I mentioned earlier, there's also a policy proposal. That doesn't mean there's a legislative proposal. It's just a policy proposal, actually based a bit on the report and the former reports. They will discuss this policy proposal during this summer, and most likely they will come up with a legislative proposal. So really the report was a trigger for this policy proposal. And they actually came up with 4 options. The first option has a lot of requirements. They will, for the duration of the non-compete, they will max this to 1 year. There should be a mandatory clarification and substantiation of the geographic coverage. What we see in practice is that sometimes a non-compete doesn't have any coverage of the geographic, so it's worldwide or Europe, and sometimes it's not needed for that scope. Nowadays, it's still valid if, in case of a dismissal during the probation period. This option suggests that it expires in the event of a dismissal during the probational period and during bankruptcy. And the clause should only be invoked in case of this dismissal on the employee's initiative. So in terms of, there's a restructuring or something like that, then this clause cannot be invoked. So if somebody thinks, or some employee wants to leave the company for another company, then this clause can be invoked. And then some conditions on the disclosure of the employer's intention to invoke the clause at the end of the employment. And option 2 is actually option 1, plus a mandatory compensation. We see that also in other countries, that the employer has to pay for the term of the non-compete enforceable. So they are suggesting in option 2 come up with a mandatory compensation for that and an optional signing fee. Option 3 is option 1 plus a competition clause only enforceable in case of an imported business interest. That's something we see now as a requirement for the employment agreement for fixed term. And option 4 is option 1 plus the mandatory compensation we mentioned earlier in option 2. And the non-compete clause is only enforceable in case of an important business interest. And that's actually, again, same as option 3. So a lot of options. Again, this is a policy proposal. It has to be discussed in, and then maybe eventually there will be a legislative proposal. On the other hand, we know that this non-compete is used very a lot. So I think that this legislator will come up with some certain limitations because it's maybe too restrictive to employees. That's not good news for employers, maybe not good news for HR, but maybe it will also help with the discussions. That's all from my side on hybrid working and the non-compete clause. You have now some airtime, Peter, on your interesting topics.
Yes, indeed. Thank you, Nikki.
And any questions in the meantime we can answer?
Let's see. There is another question with respect to hybrid working. And that is an employer obligated to approve a request from the employee to work from home?
Yeah, so of course we have this legislative proposal coming up when this request is more easily and that you have to approve it. But now if you don't have compelling business reasons or other things going on, you don't have to allow a request to work from home. That's not the case. Yeah.
All right. Great.
We'll see.
Yeah, we will see. So thank you. So moving on. So I would like to discuss with you today the position of the statutory director. And when I talk about the statutory director, I mean the statutory director of an unlisted company or a private limited company, so-called BV. And the reason I would like to do that is because the statutory director has a special legal status under Dutch employment law. And due to the status, we think it's important to look at different aspects in the employment agreement in the statutory director, of the statutory director, which is often overlooked. It's a bit technical. I'm gonna try to make it easy and explainable, of course. So again, if you have any questions, please feel free to ask. So first of all, it's good to know that the general meeting of shareholders or the supervisory board appoints a statutory director. And in most companies, the CFO, the CEO, or the COO are statutory directors. And as a statutory director, they are authorized to represent the company individually or jointly with other directors. And in general, the statutory director also has an employment agreement with the company. But before I get into the important aspects of the employment agreement, I would like to discuss some more background to give you a little bit more understanding why we deem those aspects important. So a statutory director with an employment agreement is subject to both Dutch employment law as Dutch corporate law, because they have a so-called dual relationship with the organization. On the one hand, they have an employment agreement with the company, and also they are part of the legal person managing the company. So they are a director. This means, for example, that, like I said, the statutory director should be appointed as such by the general meeting of shareholders or the supervisory board by means of an appointment resolution. And one of the most important consequences of this dual relationship is that the statutory director under Dutch company law can in principle be dismissed at any time by resolution of the general meeting of shareholders or again the supervisory board. This doesn't mean that you shouldn't provide a ground for termination. So you should still provide in the resolution the grounds for termination of the statutory director. However, in principle, when this relationship ends and this decision has been made, so the resolution has been taken on, the employment agreement of the statutory director also comes to an end automatically. And this is a big difference comparing that to a so-called regular employee for whom the employer should obtain prior approval of the Dutch court or the UWV in order to terminate the employment agreement. So the statutory director doesn't have that kind of dismissal protection. And also the statutory director cannot request the Dutch court to restore its employment agreement after he has been dismissed. One side note on that is that under certain circumstances, for example, in case of illness or pregnancy of the statutory director, where termination of employment is prohibited, the employment contract may be upheld until the prohibition expires. This also, like I said, counts for the statutory director as well for regular employees. So as you can hear, dismissal procedures with statutory directors are a bit more complicated compared to a regular employee, and for this reason we generally advise to obtain legal advice before you want to dismiss a statutory director. And like I said, that advice has to be given to or the general meeting of shareholders or the supervisory board. Now we need to move on. Do a relationship I just discussed. I think I skipped this one. So the lack of dismissal protection is not the only difference with a regular employee. There are a few other differences I think are important, and one of those are that the statutory director may conclude a maximum of 3 temporary contracts, but there's no maximum on the total term of these contracts, meaning that, for example, the usual maximum term is 36 months. So within statutory director, you can decide to agree upon a contract for 3 times of 2 years, for example, which with a regular employee is not possible, because then the employment would become employment for an indefinite period of time. Also, the statutory director has no reflection period of 2 weeks after the conclusion of a termination agreement, which what we often see in termination agreements is that still such a reflection period is given to a statutory director while it's not necessary or while it's not obligated under Dutch employment law. And finally, as a statutory director, this person can be held personally liable for policy pursuit. And if we take all these aspects into account and look at the employment contract, which is important, we find that there are certain aspects we want to highlight and think are important to include or pay attention to in the employment agreement. So first of all, that's of course the position of the statutory director, and more importantly, what regulations are applicable to him. I included board regulations, but you can also think of rules, code of conduct, etc., which kind of these regulations are applicable to the statutory director. Secondly, we generally advise to include a fixed compensation in case of dismissal, also known as a golden parachute. Such a compensation takes into account the less protected position of a statutory director in case of dismissal, and the fact that he can be held personally liable for his policies pursued. You should know that the statutory director is in principle still entitled to a statutory transition allowance. So we advise, in case you would include a golden parachute, to make sure that the transition allowance is also included in that compensation, and that you explicitly write that up in the employment agreement. Obviously, the golden parachute, the compensation, should be higher than the statutory transition allowance. Next thing would be insurance, in order to cover the liability of a statutory director, and usually such an insurance is covered by the employer, paid by the company. A notice period, which is also an important thing. So the statutory notice period for an employee is 1 month. That also counts towards the statutory director. However, what we see in practice the statutory director takes in an important position within the company, and if he would leave, that has a severe impact on the organization. And for that reason, most companies would like to agree upon a longer notice period for the statutory director, for example, 2 months, 3 months, 4 months, etc. And you have to take into account that at the time you want to extend his notice period, the notice period for the employer, the company, should be twice as long. So in case you would agree upon 2 months for the statutory director, it should be 4 months for the company. And finally, what I already mentioned, the conclusion that you can enter into employment agreement of maximum three temporary agreements, but there's no maximum on the term, so that could be something to use in the relationship between you or the company and the statutory director. So that with respect to the statutory director, I hope it was clear, although it was a bit technical. Looking at the time, I'm going to move on to my next subject, and that is the legislative proposal regarding the implementation of the EU Directive on Transparent and Predictable Employment Conditions. Bit of a mouthful. I'm going to call it the directive. And the reason why I'll talk about that is because that directive has to be implemented in Dutch law ultimately on the 1st of August 2022. And the House of Representatives and the Senate are busy to make sure that it is implemented before that time. What is the reason behind this directive is that the European Union finds that new forms of work lead to more need for an extension of minimum rights for the employee, and more information should be provided to the employee regarding essential employment conditions. And how does the Dutch government do this? So they choose to go for a pure implementation. It was a bit of a hassle to translate that to English, but I call it a pure implementation, which means that the EU directive is implemented as far as necessary, and that the Dutch government does not intend to make use of any possibilities to implement any additional provisions. The current status of the proposal is that it's already agreed by the House of Representatives, and currently it's under review of the Senate, and I expect that the proposal will pass the Senate this summer, and that the implementation date of the 1st of August, that will be implemented before that date. So what does the implementation do is that it makes some changes in the Dutch Civil Code, and today I want to discuss the most important ones, 3 most important ones. The first one being no prohibition on ancillary activities unless the employer has an objective justification or ground to prohibit those ancillary activities. The second one is that there are new rules regarding mandatory training and use of study cost clauses in the employment agreement. And thirdly, the extension of the information obligation of the employer. So I'm going to start off with ancillary activities, which adds a new clause to the Dutch Civil Code. And the starting point of this article is that an employee is now permitted to have multiple employments. And that means that any ancillary activities clause which is included in the employment contract is in principle invalid unless you have an objective justification as an employer that can justify the denial of those ancillary activities. First question that pops up is, okay, what can be considered an objective justification? Unfortunately, in the parliamentary documents, they're not very clear, or there are no really specific examples. There's one, I will talk about that later, but they mention some aspects what you can think of with relation to what can be considered an objective justification. And those aspects are health and safety, protecting confidential information, integrity of governmental services, avoiding conflict of interest, and violation of legal regulations. With respect to the moment of weighing of these interests, so how does it work? An employee mentions to his employer, okay, I have an ancillary activity. At that moment, you should weigh the interest of the employee and, of course, if you have an objective justification as an employer, so per individual case. So how does it work with respect to existing clauses? Because most employment contracts currently have a prohibition on ancillary activities unless you have the prior approval of the employer. If there are already reasons included in the clause itself, you have to look whether they qualify as an objective justification. If not, that clause will be invalid as per the 1st of August. And clauses that do not include such a reason, which is often the case, it is in principle valid until the employer relies upon such a clause. Also, until you invoke that clause without a reason that qualifies as an objective justification. So maybe also to give some insight, what can be seen as an example for an objective justification. It's mentioned that in case of violation of the Working Hour Act, so a very obvious example would be that in case someone has a full-time employment, is for example a pilot, where strict rules apply regarding working hours, and the pilot wants to enter into another full-time employment, so 40 plus 40, so he will most likely violate the Working Hours Act, or more precisely, the employer will violate the Working Hours Act. In that scenario, an employer can say, okay, I'm not going to give you any permission, or not going to give you permission, you're not allowed to enter in those ancillary activities. And finally, it's good to know that in case there has been a rejection without an objective justifiable reason, that the clause is invalid and remains invalid, so you cannot rely upon it in the future. All right, moving on to the second topic, which is mandatory training and the use of the study cost clause. And the directive made an adjustment to the Dutch Civil Code, saying the following: the employer will enable the employee to follow training that is necessary for the performance of his position and, insofar as is reasonable, for continuing the employment agreement of the employee's position if the employee's position lapses or he is no longer able to perform the function to fulfill. First to discuss the enable. How does it work? You can charge no cost for the employee with respect to the training, so with respect to the training itself, but also with respect to travel costs, study materials, examination fees, etc. Secondly, training should be regarded as working time. And thirdly, training should take place during working hours as far as that is possible. Training can also take place in weekends while the employee normally works during the week. What effect can this have on current arrangements between you and the employee is, for example, if you have a study cost clause with a right to set off, with a payback clause, for example, that can be invalid as per the 1st of August. However, then it's of course also important to know what can be considered training that is necessary for the performance, or mandatory training. And that's training that the employer is obliged to offer based on the law or an applicable CLA. And the example that is given is, for example, training regarding competence and safety, and a reference is made in the parliamentary documents to the Financial Supervision Act, for example, which states that a financial service provider ensures the professional competence of his employees. So if you have to provide your employees a training in order to make sure that he's competent enough for a service provider, that training can be qualified as mandatory training. Maybe a more clear example, if you have a truck driver who needs to extend his driver's license, then you can say, okay, that training is necessary in order to fulfill his position. And for that reason, that can be considered mandatory training, and you cannot charge the employee the cost for that training. So training considers more than only that's focused on the position of the employee. It's also training in the context of the redeployment obligation of the employer, and also training in the context of suitable work during reintegration of the employee. All right, moving on to the third point, which is the extension of the information obligation of the employer. And and that extension means that currently an employer needs to provide different kinds of information to the employee in the employment contract, which is included in the Dutch Civil Code, and that's something like a clause with respect to pension, for example, or whether or not a CLA, collective labor agreement, is applicable to the employment agreement. And through this directive, that list of information is extended, and it goes about the following points. That is about the working location, that is about the paid leave, the wage components, in case of a temporary contract, the company details of the user company, the details of the companies or bodies that are responsible for execution of any possible benefits, the policy on the education of employees, the procedure regarding termination of employment for both the employer as the employee, the length and conditions for any probationary period, and in case the work pattern of the employee is unpredictable, there needs to be additional information that needs to be provided. So that's pretty, in my opinion, pretty vague for some aspects of this. Fortunately, recently the Senate has provided some answers in this respect. So, for example, with respect to information regarding termination of employment, what do you have to provide? What do you have to state in the employment agreement? So the government answered that and say, okay, reference can be made in the employment agreement to the statutory provisions regarding termination. For example, also with respect to information regarding the probationary period, you can refer to the statutory provisions and any provisions in the applicable collective labor agreement. What do you need to do with respect to new employment agreements? You need to implement these information aspects in the employment agreement, of course, itself. With respect to existing employment agreements, you don't need to change all that before the 1st of August. You only need to adjust those on request of the employee. So the European directive also comes with some tips and tricks for the employers, or at least we have some tips and tricks for the employers. I already mentioned some, but it's important to take into account, it is immediate effective as per the 1st of August. And we're just entering the summer, so it will be 1st of August on short notice, so be prepared. Check your template employment contracts, personnel handbook, and amend those if that's required, which is likely given the new information obligations. Let's see. Make sure to work out any necessary information. So with respect to the study policy, termination procedures, make sure that you have those references correct. Also, take a good look at any study cost clauses in case of mandatory training, because those clauses can be invalid as per the 1st of August 2022. But also with respect to any new arrangements we want to make with an employee regarding training. And we would advise, in case it's not clear up front, if the training can be considered mandatory training or necessary for the position, you can put in writing that a training does not fall under the scope of a mandatory training within the meaning of 611 of the Dutch Civil Code. Doesn't give a guarantee, but at least then it's clear between the employer and employee that both doesn't regard the training as necessary. Also, of course, check your ancillary activities clause. Are there any reasons included? And if so, do those reasons qualify as objectively justified? In case a reason is included, in case no reason is included, there is no necessity to amend the clause, but you have to make a weighing of interest at the moment that the employee comes to you and asks if he wants to perform any ancillary activities. And we would advise to include a duty to report any ancillary activities, so you are aware as employer of any ancillary activities that your employee is performing, and you can make a weighing of interest whether or not you want to say that you have an objective ground to deny those activities. All right, so that's with respect to the European Union directive with respect to transparent employment conditions. And then I'm going to continue towards the paid parental leave, my last subject, which is also coming up fast, so as per 2 of August 2022. So at the moment, employees in the Netherlands are not paid for their parental leave hours, or unpaid. And this will change due to a new, again, European directive that provides for 2 months of paid parental leave. And that act will come into effect until August 2022. And what does it entail? Paid parental leave in principle applies to all employees. The duration of the allowance is 9 weeks, and the payment level is set at 70% of the statutory daily wage of the employee, with a maximum of 70% of the statutory maximum daily wage, which is approximately 3,400 gross per month. And paid parental leave is only available for parental leave taken in the first year after the birth of the child. So any remaining parental leave can still be taken up to the child's 8th birthday, but remains unpaid. So that's with respect to paid parental leave, and that's also just within time. My presentation. I'm seeing some questions popping up. First one, is it enough to refer to the employee handbook in the employment contract when it comes to the new aspects of the information obligation, and rather update the employment handbook with the new aspects? It's a good question, and like I just said, you can indeed refer to applicable CLA or statutory provisions with respect to termination, but it's not yet clear if a referral to the handbook will suffice. Personally, I think it will, because in case you also provide the employee with the handbook when you provide him with the employment agreement, but it's not yet explicitly clear from what's now currently proposed by the Dutch government. Let's see, another one. Are parents eligible to paid parental leave if their child is born before the 2nd of August? Yeah, that's a good question, because that would be it would be a little bit tragic if your child was born on the 1st of August and you won't have any entitlement to paid parental leave, but that's not the case. So how it works is that you are entitled to paid parental leave even though if your child is born before the 2nd of August. So for example, in case your child is born the 1st of June, you can take up paid parental leave after the 2nd of August 2022. And you still are entitled to 9 weeks of paid parental leave. It's only, if your child is born before 2nd of August 2021, you can no longer claim a paid parental leave, because then your child is older than 1 year after the 2nd of August 2022.
Maybe good to add. That paid parental leave is not out of the pocket of the employer. You have to apply to UWV. Of course, you can supplement that as an employer for employability, but you needed to make an application as similar to maternity leave.
Yeah, correct. Good addition. So indeed, you as employer are not bearing the cost of paid parental leave. So I think we can close off our presentation. I want to thank you all for following our presentation, and thank you for your attention today. And hopefully we can see you in the future, and wish you a nice day.